Ladies and gentlemen, welcome back to another legal breaking reporting. In this afternoon's legal breaking reporting video analysis update, we have two legal breaking reportings. First, ladies and gentlemen, the Supreme Court of the United States, who just so happens to be, unfortunately, right-wing communists, are about to decide the constitutionality of Donald Trump attempting to limit birthright citizenship in violation of the 14th Amendment of the United States Constitution, which is not considered under presidential immunity covered. Our second reporting is of Obamacare. Specifically, ladies and gentlemen, that article is titled Obamacare Anxiety Rising Among House GOP centrists to do this buffoonery by the Hill. We will get to that reporting, but first, let's get to the Supreme Court ruling potentially and deciding on Donald Trump's illegal constitutionality of attempting to limit birthright citizenship by New York Times. Both of these reportings, ladies and gentlemen, by the New York Times and The Hill, are both read by an automated voice to us, so we will be taking a look, a read, and a listen. Ladies and gentlemen, before we begin, please like, comment, share, subscribe, and enjoy, and hit the bell icon as well as the all notifications options.
Supreme Court agrees to review Trump order restricting birthright citizenship. This article is by Abby Vansickle and read by an automated voice. The Supreme Court announced on Friday that it would hear a landmark dispute over the constitutionality of President Trump's effort to end birthright citizenship. The legal fight stems from an executive order signed by the president on his first day back in office, declaring that children born to undocumented immigrants and to some temporary foreign residents would no longer be granted citizenship automatically. The executive order, which was immediately passed by courts without going into effect, would upend the commonly accepted view of American citizenship guaranteed since 1898, that citizenship should be extended to anyone born in the United States. It could throw into doubt the citizenship of hundreds of thousands of babies born each year. The court has not announced a date to hear oral arguments, but the justices will most likely hear the case in the next few months. A decision would then be expected by the end of June or early July. The case joins what is already a consequential term for the court, as the justices hear a series of challenges to other presidential actions, including Mr. Trump's sweeping emergency tariffs, his firings of the heads of independent agencies, and his push to remove a governor of the Federal Reserve Board. In addition to those tests of presidential power, the court is weighing legal fights over transgender athletes in girls' sports, a challenge to a central tenet of the Voting Rights Act, and a high-profile Second Amendment case. Birthright citizenship, the idea that virtually all children born on American soil are automatically citizens, regardless of the status of their parents, has long been considered a core tenet of the country. That notion, which is rare among the most developed countries in the world, is grounded in the language of the 14th Amendment. The amendment, ratified after the Civil War, states, "All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside." Mr. Trump has long expressed skepticism about birthright citizenship. After winning his second term in November 2024, he told NBC News during his first extended interview as president-elect that he would end the practice. "We're going to have to get it changed," he said then. "We're going to end that because it's ridiculous." Allies of Mr. Trump have argued that the 14th Amendment was intended to extend citizenship only to the children of formerly enslaved people, and has been wrongly interpreted as applying to the children of undocumented migrants. The theory was once considered a fringe view, but Mr. Trump's embrace has popularized it among conservative thinkers. Mr. Trump attempted to follow through on his promise, signing the executive order that said the policy would go into effect in 30 days. But legal challenges came almost immediately, and judges in Washington state, Maryland, and Massachusetts quickly froze the policy for the entire country. One federal district judge in Seattle, John C. Coffener, called the president's order blatantly unconstitutional. Lawyers for the Trump administration asked the Supreme Court to weigh in, but the government did not at first focus its legal arguments on the merits of the president's policy. Instead, the administration's lawyers asked the justices to consider whether trial court judges had exceeded their power by granting nationwide freezes on an executive order, a long controversial practice known as a universal injunction. The justices heard oral arguments about legality of universal injunctions in May. In June, in a 6-3 decision, split along ideological lines, the justices sided with the Trump administration, sharply curtailing the power of district court judges. Hours after the Supreme Court announced its ruling, the American Civil Liberties Union filed a lawsuit challenging the president's birthright citizenship order once again. This time, the civil rights organization tested the reach of the Supreme Court's decision by bringing a class action lawsuit, which the justices had said remained an appropriate legal tool for addressing policies that affect large groups of people. The challengers asserted that all children born after the president's executive order was scheduled to go into effect, along with their parents, constituted a class. The ACLU argued that, for many families throughout the country, birthright citizenship represents the promise that their children can achieve their full potential as Americans, and warned that the president's order would risk rendering effectively stateless children born to parents in the country unlawfully. To the Supreme Court, the ACLU has argued that the court should uphold precedent it set in the landmark 1898 case of United States v. Wong Kim Ark, when it held that Mr. Wong, who was born in San Francisco to non-citizen parents, was himself a citizen. In a statement on Friday, Cecilia Wong, National Legal Director of the ACLU, said that, for over 150 years, it has been the law and our national tradition that everyone born on U.S. soil is a citizen from birth. The federal courts have unanimously held that President Trump's executive order is contrary to the Constitution, a Supreme Court decision from 1898, and a law enacted by Congress, she added. In July, Judge Joseph N. LaPlante of the U.S. District Court for the District of New Hampshire sided with the ACLU, certifying a class action lawsuit. In a brief to the court, Solicitor General D. John Sauer asserted that the 14th Amendment was intended to ensure citizenship after the Civil War for the newly freed slaves and their children, not on the children of aliens temporarily visiting the United States or of illegal aliens. The view that the 14th Amendment guaranteed citizenship to children born on U.S. territory was mistaken, Mr. Sauer wrote, and had become pervasive with destructive consequences. He asserted that Mr. Trump's order would merely restore the clause's original meaning.
With that, ladies and gentlemen, I honestly don't agree with Solicitor General D. John Sauer, mostly because this prick decided to illegally give Donald Trump presidential immunity. Fucking fascist piece of shit you are, John Sauer. And I don't care who I offend. With that, ladies and gentlemen, and that disgraceful reporting, let's turn to our next reporting by The Hill. Ladies and gentlemen, I'll remind you guys once again, please, if you have not already, please like, comment, share, subscribe. It'll help me out in producing legal breaking analysis reportings to you guys. Without further ado, ladies and gentlemen, let's get into the second legal breaking reporting video analysis update, which would technically be the third legal breaking reporting for the afternoon of December 5th, 2025, Friday.
Obamacare anxiety rising among House GOP centrists. To do this is buffoonery, by Nathaniel Weichsel and Mike Lillies. Frustration is mounting among moderate House Republicans as various competing health care plans appear to be going nowhere, with less than 10 working days left on the calendar before millions of Americans see their health insurance premiums spike. A small but animated group of GOP centrists is imploring party leaders to extend the Obamacare tax credits set to expire at the end of the year. But they have run into a wall of opposition from Speaker Mike Johnson, Republican from Louisiana, who is cold to the idea, and a larger group of conference conservatives who are openly fighting to have the subsidies end. The resistance from the top has prompted warnings from a growing number of Republican moderates that their thin majority will be lost in next year's midterms unless GOP leaders hold their noses and extend the enhanced payments to prevent a spiral in out-of-pocket costs for more than 20 million Americans. It is just bad to go into a very tight midterm election and be hurting, 20-some million people in the country, said Representative Jeff Van Drew, Republican from New Jersey. To do this is buffoonery, Van Drew added, referring to Republican inaction. I want to be in the majority next year, and this makes that much harder because of the districts that are so close. There are a handful of competing ideas circulating among Republicans, but there is no consensus on which plan to coalesce behind. Some plans would extend the subsidies for 2 years, some for 1 year. Almost all have new restrictions, though they differ on the specifics, and none addresses abortion, which is a significant stumbling block to any compromise. Representative Jen Kiggans, Republican from Virginia, has introduced both a 1-year extension and a 2-year extension. A pair of GOP lawmakers, Reps Don Bacon in Nebraska and Jeff Hurd-Kolo, have championed a 2-year plan, and Representative Brian Fitzpatrick, Republican from Pennsylvania, is racing this week to finalize a separate 2-year proposal. But none of them has won a commitment from GOP leaders to get a vote on the floor, a mistake in the eyes of the moderates. The details of each individual plan are not as important as the desire to get it done, Van Drew said. I hate Obamacare. It is wrong, it is bad, it is corrupt. However, in the short term, fix it immediately, as quickly as you can. We only have a few weeks here. The White House floated its own plan to temporarily extend the subsidies for 2 years, paired with reforms similar to those included in the various House proposals. But the leaked framework was quickly pulled after a mountain of internal GOP criticism. Johnson further undercut efforts to build momentum behind a particular plan when he told reporters Thursday that GOP leadership would be presenting its plan, with a vote by the end of the year. It is unclear whether Obamacare subsidy extensions will be part of that package, but Majority Leader Steve Scalise, Republican from Louisiana, said it would not include a bipartisan framework for a temporary subsidy extension introduced Thursday by Kiggans and Josh Gothamer, Democrat from New Jersey. Representative Kevin Kiley, Republican from California, who supports the Kiggans and Gothamer plan as well as his own, said it would be a mistake for GOP leadership not to hold a vote on the expiring subsidies. There is a strong majority that exists for doing something to stave off the worst outcomes here. I think there is enough points of consensus in the various different ideas that we should be able to get a deal done, Kiley said. If people are forced to pay thousands of dollars more and are unable to afford insurance, then they are going to hold Congress accountable. Centrists are looking to build bipartisan support for an extension of the subsidies, a Democratic priority, with some new restrictions aimed at conservatives, like income-based eligibility caps and the elimination of plans without premiums. Without congressional action, premium payments are set to spike for tens of millions of people, starting January 1st if the enhanced subsidies expire, and the most vulnerable Republicans up for re-election do not want to be blamed. Any idea needs to be bipartisan, since it will need 60 votes in the Senate to pass. House moderates are hoping at least one of their plans can be the basis of a compromise. Senate Republicans promised Democrats a mid-December vote on a plan of their choice to extend the subsidies. That vote could happen as early as December 9th, leaving little time for lawmakers to come together on an alternative if it fails. Senate Minority Leader Chuck Schumer, Democrat from New York, announced Thursday their plan would feature a clean 3-year extension. That proposal keeps Senate Democrats squarely aligned with Democrats in the House, where party leaders are urging Republicans to join a discharge petition, with no success so far. The path forward that has the greatest number of votes in both the House and the Senate is a 3-year extension, House Minority Leader Hakeem Jeffries, Democrat from New York, told reporters Thursday. Time has run out. But the 3-year plan has little chance of winning the Republican support needed to become law, because it does not include any of the reforms demanded by even the moderate GOP lawmakers. I do not buy the 3-year clean extension. That is DOA, Bacon said. Most of us want a 1 or 2 year extension that has some modifications on incomes, on various other things. The Senate Democratic plan does not acknowledge the flaw in the construct of the tax credits, Fitzpatrick said. You have to focus on the low and middle income earners. The current construct is that you can earn $600,000 a year and get subsidies. We have got to focus on the people that really need it. Fitzpatrick said his nascent proposal has a better chance because it already has bipartisan buy-in. It has got House, Senate, and White House input from both parties. So that is going to be our best product we can put together, he said. As a last-ditch effort, Fitzpatrick is prepared to introduce a discharge petition, which can force a vote on any bill if 218 House members sign on, if Johnson does not bring the legislation up for a vote. Getting a deal through the House and Senate is a political minefield. For the centrists, it is not for lack of effort, though some admit that having so many competing ideas only makes it harder. Bacon, who is retiring after next year, said he has co-sponsored separate bills that are all slightly different in an effort to find common ground. A temporary extension is not solving the problem, it is throwing more money at it. But we need to do something temporary, just so we can find something better. Bacon acknowledged the conservative objections over doing anything to help Obamacare, but said that is not a politically feasible option for most members. If you are in an R+20 or R+30 district, you can do that. But I have a heart for the guys paying premiums, Bacon said.
With that being said, ladies and gentlemen, that is going to do it for this legal breaking reporting and video analysis update. If you did enjoy this legal breaking reporting and video analysis update, the second one for the afternoon of Friday, December 5th, 2025, please like, comment, share, subscribe, and enjoy, and I will have much more to come very, very soon. Ladies and gentlemen, as I said before, please like, comment, share, subscribe, and enjoy for more legal breaking news that you need to know about by hitting the bell icon as well as the all notifications option. And I will look forward to talking to you guys in my third legal breaking reporting video analysis update for the afternoon of Friday, December 5th, 2025.